After 35 years of military service, General Sejusa, a decorated military officer who fought in the Luwero Bush War alongside President Museveni, walks the tightrope as he tries to defend himself against a raft of charges in the General Court-Martial. During yesterday's trial, a legal ping-pong ensued over whether the court-martial had the jurisdiction to try Sejusa, who has at the same time petitioned the High Court, seeking a declaration that he is no longer a serving officer of the UPDF. Through his lawyers, Sejusa opines that under the principle of constructive dismissal, he is a civilian after the army declined to respond to his application.
And our position is firm and very clear that he should not take a plea on those matters because there is a matter pending before court, and which is crucial. There is some issue. It is a matter of law to be determined whether he is still a serving officer or not.
Appearing on NTV's Newsnight, the army spokesperson, Paddy Ankunda, revealed that constructive dismissal is a fallacy under the UPDF Act.
As far as retirement is concerned, General Sejusa applied through the CDF to the Commission's board to leave the army. His letter was received, just like all the others were received. The letter is being discussed. It is being considered, like all the others. He cannot put pressure on the institution.
Robert Chirunda, an advocate, revealed that there is a lacuna in the UPDF Act on the interpretation of what happens after the 90 days have expired for an officer to retire from the army.
Unfortunately, when the framers of the UPDF Act wrote that section, I believe section 24, they did not stipulate what happens if in 90 days the response does not come.
Sejusa's lawyers have also raised queries on why their client has not yet been retired, yet his Bushwar comrades were discharged.
I can mention names of generals who are retired after he had submitted his application. He had requested to be discharged in 1996, including General Museveni, General Tsar, General Kahindo Tafire, General Muhwezi, General Tumukunde, General Mugishamuntu, General Viraro, General Charigonza. All those generals, they were retired after he had submitted his application.
Sejusa, a member of the historical High Command, was the first to apply for retirement in 1996, but his request was declined. This sparked a protracted legal battle, and eventually a 1997 Supreme Court decision ruled in favor of the establishment. Whereas many of his colleagues have been retired, Sejusa says he continues to be a political prisoner, held in his own conscience. The trial over High Command member General David Sejusa in the court-martial has opened what is undoubtedly the can of worms on the political participation of serving army soldiers in the politics of the country. While many say that the law has taken its due course, some argue that the same law has not taken its course for generals who voice opinions that are in favor of the ruling elite. Chirunda argues that the trial will enrich the country's legal jurisprudence, and it will be a litmus test between the power of the army and that of the judiciary as an independent arm of government.
We argue the same about the Electoral Commission, we argue the same about the Uganda Police Force, you raise the same question about the UPDF, we argue the same question about the NRM Congress Parliament. The question is, do we actually have institutions that are independent of the interests of the regime in power?
If convicted, Sejusa could face dismissal from the army with disgrace and a lengthy 30-year jail term. Raymond Mujuni, NTV.